So this has to do with some of the difficulties facing the Muslims in the West regarding engagement and marriage. The topic of this talk is that two matters. The first one is the unreasonable refusal of the guardian and mechanism of checking it, and the other aspect is the compatibility of the spouse. And so essentially unreasonable refusal and compatibility. Those are the main two topics that will be discussed that are facing the young Muslims or Muslim youth during the time of engagement. So the topic is the refusal has to do with allowing the female to marry a compatible pilgrim. However, it has nothing to do with if a person is preventing or refusing due to incompatibility. In unreasonable refusal is preventing the guardian the marriage of his the female he is in the guardianship over the female without legal Islamic legal right, such as preventing her from marrying a person who is compatible with her. However, if the person who has approached for engagement and that she accepted him is incompatible, this is not considered a unreasonable refusal by the wali. Now, there is no difference in opinion in the impermissibility of refusing a person or a female from marrying a compatible person, because this is considered a form of oppression and a transgression that defies the objective of the guardianship over the marriage. As the guardian is supposed to look into the welfare of the individual that he is given guardianship over. As Allah subhanahu wa ta'ala said, وَإِذَا طَلَّقْتُمُ النِّسَاءَ فَبَلَغْنَ أَجَلَهُنَّ, if you have divorced a female and they've reached their time of iddah, then don't prevent them from marrying their spouses if they تَرَاضَ بَيْنَهُم, which means they reconcile between them in ma'ruf. So this has the evidence for that is one of the companions of anhu. His sister has been divorced, and her divorcee wanted to take her back again. However, he had refused, even though his sister wanted to reconcile and go back to her husband, but he prevented her. And so she had went to, and Allah subhanahu wa ta'ala has revealed the verse to direct the guardians not to unreasonably refuse their the individuals that they have guardianship over from getting married. And if the closest guardian has acted upon or has performed unreasonable refusal, then his guardianship is dropped and it moves up to the next individual of kin in line. However, they have different opinion of who is the one that's gonna the guardianship move to afterwards. And so there is an order. However, there's a difference between the scholars of what this order is of guardianship. So the first opinion is the opinion of the Hanabila and the Shafi'iyya, is that the one next afterwards is the one who's going to conduct the marriage contract, who's going to be the guardian. Now the second opinion is that it is the sultan who is the leader or the king or the ruler of the person. He is gonna one that is supposed to take guardianship and conduct her marriage, and this is the opinion of the Malikis and the Hanafiya. And the Shafi'is have that opinion if the i'dal or the unreasonable refusal has been repeated often. And so, just to recap, if the guardian practices some sort of unreasonable refusal to marry his muwaliya, the person who's supposed to be a guardian over, then he is not considered a guardian, it is dropped. He considered a person who is sinful, and his guardianship is removed from this aspect, but they differed who's the one who's going to carry the marriage contract after that. The first opinion is that it is the next person in line, and the second opinion, it is the ruler who is going to conduct that. And the ruler has the ability to get her married without the permission of her guardian. And in the hadith of Aisha anha, that the Prophet ﷺ said, any female who gets married without the permission of her guardian, then her marriage is batil, her marriage is null. And if he has consummated the marriage, then she has the dowry or the wedding gift because of the consummation that happened. And if they have disputed to the ruler, then the sultan or the ruler is the guardian of the person who has no guardian. And so, in summary, if the guardians have unreasonably refused to conduct the nikah or the marriage of their person that they have guardianship over, then the wilaya, then the guardianship is transferred to the sultan or the ruler. And a person who also is considered in place of the sultan is the judge. And this is in the Muslim world, in the Muslim regions. And however, in the West, then it is the leaders of the Muslim societies, such as the Imams. They take the role of the either the ruler or they take the role of the judge. The second topic is not responding to the messages regarding the proposals. So essentially, this is a refusal or unreasonable refusal of marriage due to the absence of the guardian and him not returning back any sort of communication. And so the jurists in this matter, when they talked about an individual who a guardian who's away from the country, local area or community where he's supposed to be, where there is and so if the female has other relatives or kins, such as brothers or uncles or grandparents, then the guardianship is moved to the closest one after that, and they're the ones that would conduct her marriage contract. However, if the opinion that the imam or the ruler is the one that would conduct her marriage contract directly would elevate some of the hardships or inconvenience or difficulties that would be associated with having to move to other relatives in the absence of the guardian. And so the Sheikh recommends that in the case where there is an unreasonable refusal for the marriage by the guardian, then it immediately gets transferred to either to the judge or to the guardianship gets transferred to the judge or whomever takes his position from the Muslim Imams. Or if the guardian is absent, then does not respond to communication, then he's treated the same way as a person who unreasonably refuses marriage for his guardian. The person he's guardian over. Now, in terms of compatibility, it means compatibility between the two spouses in specific matters, and the scholars have talked about the prerequisite for that in terms of marriage, and we'll talk about the compatibility in faith, in lineage, in trade, and in wealth, with the difference among them of having those aspects as a prerequisite in 4 ways, in 4 matters or 4 ways. However, we should also bear in mind there are certain situations that we have to bear in mind. For example, a situation where a female is either elderly and she has been divorced, or she is a armala, a widow, and she has children, and then her chances of getting remarried again are slim, and then a person who is compatible comes and it proposes for marriage, and if they refuse that, then her chances of getting married are even slimmer. Then in this case, perhaps certain things should be bear in mind to do what is more favorable for the right of the person that they are guarding over. Once again, going back to the compatibility, it is being compatible in specific things between the spouses, in specific matters. And so they've talked about the compatibility in faith, in lineage, in trade, and in wealth, with the difference between them, with having those prerequisites in there. Some have spoke about the person being free, or they're being emancipated. Are these considered things that would be defects in or deficiencies in the compatibility or not? But they also talked about aspects that are considered defects in the body that would prevent the purpose of marriages and the difference between them. However, they have agreed that compatibility is a valid prerequisite in the nikah and the marriage. However, they differed. So they actually they used as evidence the hadith of Aisha radiallahu anha. The Prophet ﷺ said, "Khayyaru linutfikum," select for your offsprings and get married al-akiffa, right, and give into marriage to the ones who are compatible, and marry them off and get married to them. And there's another hadith that people are compatible to one another, except that he mentions specific trades that are considered low trades, such as the person who performs hijama for money. However, one of the scholars has said that it is weak in narration. However, it is acted upon. However, also we have to bear in mind that the scholars had differed. Is this a prerequisite, a shart, a condition of validity, or a condition of ilzam, which is to make sure that it has to be fulfilled, that a person is considered liable for it. And so those who said that it is a condition or prerequisite for validity said that if the compatibility is not there, then the contract is invalid. And then whomever made the compatibility a prerequisite for luzum, which means is liable, has to be fulfilled, then the contract is valid, and her guardians have the right to nullify the contract after that marriage, to prevent any sort of harm befalling her. So the origin of marriage is that it's considered a necessity. However, the marriage having mawadda between them, it's considered an aspect of need, love and affection between them. It's considered a aspect of need, and without it, there'll be difficulty in marriage. And what completes the aspect of love and affection is compatibility between them. So if the spouse is compatible, then this is more likely that a aspect of mercy and love and affection will grow between them. And so it's one of those things that would be complete what is considered a need-based aspect. Compatibility, regarding compatibility in faith and in lineage, this is the prerequisite for compatibility in faith and religion. It is a consensus between the scholars, and so a female who is chaste, or a spouse who is chaste, is not compatible with the person who is unchaste. or a person who is sinful to a person who is righteous. However, of course, based on can have bear in mind that there's difference in opinion. If a person who is sinful gets married to a person who is righteous, is the contract considered invalid, or is in fact the contract considered valid? And so in this case, it goes back to the prerequisite. Is it a prerequisite in the validity of the contract, or for the liability of being implemented? عايز اوطي لا لا اوطي They did differ in terms of accountability in lineage, and so the majority of scholars have accepted that it is a prerequisite based on the opinions of the companions of anhum, that the person who has been freed as a slave would not be compatible for a originally free Arab female. And some of the other scholars said that it's not considered a prerequisite in terms of lineage, such as the Malikis and Al-Karqi from the Ahnaf and Ibn Taymiyyah rahimahullah. And those who did not said that it's not a prerequisite, based it on the verse of Allah subhanahu wa ta'ala, إِنَّ أَكْرَمَكُمْ عِنْدَ اللَّهِ أَتْقَاكُمْ, that the most noble of you in the eyes of Allah subhanahu wa ta'ala, the eyes of Allah subhanahu wa ta'ala, is the one who has more taqwa. And also what the Prophet sallallahu alaihi wasallam told the companion radiallahu anha, Fatima bint Qais, he told her to marry Osama, and Osama was a freed slave, and he approved it. And also the marriage of Salim, the freed person of Abu Hanifa, to one of the other companions, female companions. And so there are circumstances in the Sahaba Sirah where the lineage or in terms of socio-economical aspects is not considered a compatibility aspect of prerequisite. So these are some of the some of the evidence that some of the scholars had used to say that compatibility only should be in faith and religion or religiosity and not in lineage. Now, discussing the compatibility in wealth and in trade. When it comes to wealth, so for example, if the female is wealthy, then the compatibility over here is looking for a husband, a male spouse that is a groom that is of the same level or richer. However, the other way around is not usually considered. For example, a rich groom searching for a bride, even if she's poor, that's not considered an issue of compatibility. And so when it comes to the opinions of the scholars regarding compatibility in wealth, then the Malikis and Shafi'is, and an opinion in the school of Imam Ahmad is that it's not considered prerequisite. Because wealth is something that people of chivalry do not gloat with, and it's something that is it is threatened to be lost, and so people can become rich or become poor. And it was not mentioned or reported from the Prophet ﷺ any sort of authentic narration that placed it as prerequisite that wealth be as a form as prerequisite. And those who had, and the evidence of those who had placed the wealth as a prerequisite is al-urf, which is essentially what is the norms. And so the evidence essentially is the norms, and this is, for example, the Al-Kisai from the Ahnaf, who, by the way, the have a prerequisite is that wealth is considered a compatibility, mentioning that usually the person who wealth is considered a compatibility in the norms that they're in. Now, when it comes to trade, then that whole aspect of trade is not really considered compatibility based on the opinions of the Malikis, and a narration and from Imam Ahmad rahimahullah, because there was no report from the Prophet ﷺ, any sort of authentic evidence that puts prerequisite in compatibility or equality in sort of the level of trade. And so in the previous generations, the trades that were there, such as any sort of trade that had to do with contact with people's awrat, then is considered something that is a bit more lowly, which requires a person would touch the awrats of individuals, such as a tailor or a person who has any of those trades that are associated with that. And so they would consider that an individual who has a trade that is considered more of a low class. And so they would consider that aspect of a compatibility. However, there is no evidence that puts compatibility in trade that is clear in that. And whomever from the scholars who placed compatibility as a prerequisite or of compatibility, they use the evidence of the norms, cultural norms, as the aspect of the evidence associated with it, because of how people look at the individual who's proposing. For example, people who work in farming is considered less in status than people who are involved in trade, for example. Now, the mechanisms for tackling things that are associated with compatibility with the spouses, and it happens quite often in the States, for example, or in the West, is that the female would desire to marry an individual, a groom who differs from her cultural background, or a person who just accepted Islam, or that he has been married before and she has not been married before, or that he's a widow. And so these are different circumstances that occur more often in the West than we see them in the Muslim lands. And so would this be considered part of or going underneath the guardian would prevent her from getting married to a person who is they would consider incompatible in this aspect? And so these are matters that the jurists have not considered. For example, a person accepting Islam, or a person who is a widow or has been married before and divorcee. These things that were not considered in terms of jurisprudence, a aspect that will be considered of compatibility. However, in modern days in the West, these are certain things that we are faced, where they would be interested in marrying a person from a different culture or a different nationality, or they are widowed or been married before, and to the end of those things. And some of these aspects would prevent marriages from being completed based on people's traditions or their norms. However, for the new generation that are coming out, we should notice that these matters are considered outliers, and those things don't matter. So they don't worry about these aspects, similar to how their parents would worry about them. And so we have to take those things into consideration. And so we think that the Imam of Islam or the Imams of Islam would look into the aspect of the young female, if she's desirable and she has possibly a lot of suitors, then the guardians might have a feeling that if they wait, they will have a better suitor. Then in this case, that the leader or the community, or the imam of the community, would not consider the father or the guardian a person who's practicing unreasonable refusal. Because in this case, perhaps in their eyes, it would be considered a person who's incompatible, especially if they expect that she would have a lot of suitors, that somebody who would be more compatible would propose to her. However, if the female was in a situation where if she would obey her guardian and she refused to get married to the person who proposed, that she does not expect that anybody who's more suitable than him would propose to her, then the imam of the center would try to exert his best effort to do what is best for the female in this case. Allah A'lam, and all praise belong to Allah subhanahu wa ta'ala.
We understand the topic for the chair for addressing these two important and sensitive issues. Unreasonable refusal of the way to and how we tackle this. Inshallah, in the next Q&A session, after the talk of Sheikh Mofa, we'll address all the questions together, inshallah. And the second question, which was the compatibility, between Islam and culture and how to navigate this. So, inshallah, the questions will be referred after the session by Shaykhna Dr. Al-Galaieni, inshallah, to address another two important and sensitive issues as well. The one, the first,
الشيخ موفق الغاليني حفظه الله سيتحدث عن موضوع منع الإنجاب قبل التثبت من استقرار العلاقة الزوجية. هذا الموضوع الأول. والموضوع الثاني المسكنة الشرعية، ضروريتها والتعامل مع هذا اللفظ من الناحية الشرعية الإسلامية. والموضوع الأخير هو أحكام الأولاد غير الشرعيين. إن شاء الله نؤجل جميع الأسئلة لكلا الشيخ وليد إدريس والشيخ موفق الغلايني إلى آخر الكلمة إن شاء الله أو المحاضرة. وعليكم السلام ورحمة الله وبركاته. All praise belong to Allah subhanahu wa ta'ala. Peace and blessing upon the Prophet sallallahu alaihi wasallam, the most noble of prophets, our Prophet and Messenger Muhammad sallallahu alaihi wasallam. The Sheikh says I have interesting luck. My talk is after everybody has filled their stomach, and they say if the stomachs are filled, then the minds are covered or concealed. But I see, mashallah, that the coffee and tea is there. So perhaps, inshallah, that you get awake and become alert to what I'm going to say. Listen and comprehend. The Shaykh asking Allah subhanahu wa ta'ala to direct him and allow him to succeed. The first topic has to do with having children before confirming that the marriage is deemed stable. This is one of the modern fashions. Is that the couples temporarily suspend producing offsprings. One institution is that perhaps that the female spouse or the wife is still a student in college, is a student in the beginning of marriage, and so they would delay having kids until they might have graduated. I'm going to use a joking methodology to keep you awake with me. I'm worried that you guys are going to fall asleep during the talk. First of all, Allah subhanahu wa ta'ala said that one of the objectives of marriage is seeking children. Allah subhanahu wa ta'ala said, now approach him and obtain what Allah subhanahu wa ta'ala has written for you. That's referring to offsprings. And usually females desire children more than men. However, subhanAllah, unfortunately, some of the married females, their love to their careers or to their studies is more important than having children. However, this is the reality that we live in. And as you can see from the honorable mashayikh, that Islam was built on ease. And so the Sheikh says it's permissible to use some sort of preventive measures to prevent reproducing, as long as it's not something that is permanent. So these are considered temporary methods that would delay marriage. Not delay marriage, but delay having kids. In the olden days, there was no sort of contraceptives. They didn't have any sort of contraceptive pills. So what they had is what is considered a not allowing the insemination, which means essentially the semen would be allowed to, the male would not allow the ejaculation to occur within inside the female. And so they would ejaculate outside the female. And And so the evidence for that permissibility of that is that Allah subhanahu wa ta'ala, when the Jewish community said that what the Muslims are practicing in terms of ejaculating outside of the female's uterus is considered a part of a kind of jihad, which is causing some sort of miscarriage or abortion, and then Allah subhanahu wa ta'ala said they had lied. If Allah subhanahu wa ta'ala wanted something to happen, it will happen. And so the ruling is that there is a necessity or need to delay pregnancy, then it's okay to temporarily use some sort of a contraceptive until they are ready to have their children. So this is the ruling of using temporary forms of contraceptive, as long, once again, is not something that is permanent. However, it is important that both spouses agree to this. Both males and females need to agree on delaying this aspect, because none has the right to delay the other person's desire to have children. Among those who have mentioned that is Imam Al-Kasani, Sheikh Muhammad Salih Al-Uthaymeen, and it's the opinion of the Majma' al-Fuqaha jurists of Islam. Now, cohabitation, the aspect of talking about cohabitation. We're talking about Islamic cohabitation. So what the Sheikh is talking about, there's quite often that there's more females, more Western females approaching the centers to accept Islam. And they have as more than men. And the Sheikh is asking, why is it they're looking for Islam? Because they realize that Islam honors them. And there are rights for them. The Sheikh is just making some comments regarding, a person marrying a female from a higher status and complaining that he's not being served. Why not marry from a person, from the same socioeconomical status? The Sheikh Hafidhullah is going back to the topic, and he said, and give them housing from where you are capable or you house yourselves. that harm, do not, the Shaykh recites the meaning of the verse, which is do not deprive them or harm them to constrict upon them. When it talks about cohabitation, it is it's a responsibility of the spouse to provide a housing for his wife. What is the prerequisite of the housing? There are different opinions. Some opinions say that the housing or the level of the housing should be based on what she desires, how the wife desires. And the other opinion is that it's based on what the husband is capable of. And we have to remember that marriage is built on love and affection and mercy. And when it comes to her rights being dropped due to a form of disobedience, so when we're talking about insubordination, it comes from the Arabic word nashiz, which means aspect of elevated, which means a person places themselves above somebody else. For example, gloating about a person, lineage over somebody else, or their wealth over somebody else. And so the Shaykh is saying, for example, if a female is gloating over her husband and she's saying I'm better than you, whatever the case is, and then she leaves the house without excuses, this is the verse that Allah subhanahu wa ta'ala talks about in terms of insubordination, when a female acts upon some sort of insubordination and disobedience to her husband. And in what category is talking about? It's talking about in terms of that category. And so Allah subhanahu wa ta'ala said, remind them, فَعِظُهُنَّ وَهَجُرُهُنَّ. Right? And so Allah subhanahu wa ta'ala said there's three methods. There is reminding them, and then there is leaving from, departing, leaving, is avoiding or departing away from sleeping with them in the same bed. And the other one is that has to do with some sort of what is considered a darb, which is a form of striking, but based on the sunnah. Most situations are dealt with or can be solved by the first two methodologies, which is warning them or just physically not staying with them in the same bed. The Shaykh is talking about discretional punishment. And this type of punishment that He said that this is a type of discretional punishment, is a type of punishment that is based on what the judge sees as something that is befitting, and the least of it is that looking upon a person and with a stern look upon them, and the maximum of them is a specific number of lashing. And so the Sheikh is saying that also when it comes to dealing with insubordination from the female, he said, like, when you're talking about those three things, either warning them and then not staying with them in the same bed, and then in the end, if those don't work, then you talk about the last level, which is reprimandation through a form of a striking. But even the scholars say that one is better than, which is that better, or these three methods are better than divorcing. So the Sheikh is talking about a situation where, for example, a complaint that came to him that the father of a wife of his daughter, he came to complain. He said that her husband is not giving her financial rights, and the husband is saying, she's never at home. She's always out of home. I don't see her. How am I going to give her any sort of financial, her financial rights? The last thing that we're going to be discussing is actually, when I talk about the financial responsibility being dropped by insubordination, many of the scholars had mentioned that. So, regulation concerning children born outside of wedlock, and so the ruling is that that child that is born out of wedlock is considered free out of sort of a sin, and he has no sin upon him and no shunning upon him, and the punishment is on the parents who had performed that act of adultery or illicit sexual behavior. As for the hadith, is that the son or a child of a female who committed zina will not enter Jannah. This is a fabricated hadith. As for the authentic hadith, it is the statement of the Prophet ﷺ that there is nothing upon the child born out of wedlock any sort of sin from what his parents had committed. However, is the child attributed to the lineage of the male who had committed zina, or is he attributed and he takes the family name and lineage of the mother? The Islamic ruling is that he is attributed and takes the family name and lineage of the mother. The Sheikh has mentioned that also in terms of inheritance, is that the father the father of the child out of wedlock there's no inheritance between them or between the mother, because this is a marriage that happened, or this is a illicit sexual behavior that happened outside of marriage, which means it's invalid. If it wasn't for Islam, then Abu Jahl would continue to threaten us, and Allah subhanahu wa ta'ala expand our hearts to Islam. Allah subhanahu wa ta'ala make us among who love your legislation and make it beloved to other people. Allah subhanahu wa ta'ala allow success to happen to those who call to Allah subhanahu wa ta'ala to what you would love, and allow them to be among those who would open the hearts of people to Allah subhanahu wa ta'ala. And the last of our dua is Alhamdulillah Rabbil Alameen, and peace be upon the Prophet sallallahu alaihi wasallam. سيضيف الشيخ صلاح الصاوي بعض الكلمات قبل أن نفتح النقاش إن شاء الله. وعليكم السلام ورحمة الله. Ask Allah subhanahu wa ta'ala to give tawfiq to Shaykh Muwaffaq and reward him for what he has presented. And this is a quick footnote regarding the statement, the beautiful statement that he had made, or the presentation he made. As for the first thing, or the first topic that was discussed, which is not having children until the marriage is deemed stable, I would like to say, my beloved brothers and sisters, is that in this chapter there is a recommendation by the jurists, is that there is a difference between permanent measures that prevent having children, pregnancy, and those measures that are considered temporary. And so it is permissible to have reversible forms or temporary forms of contraceptive for a small period of time, to prevent pregnancy from occurring, as long as they both the husband and the wife agree with one of them and there is no harm upon either of them, and the means that is being used is permissible. As for cohabitation, the legal Islamic cohabitation, what is intended with it is the right of both spouses that they will be under a housing that gives them privacy, where they feel in it some sort of love and affection and peace among them, and which they share the difficulties of life among them. They're both the gains and the losses in that life. So the legal cohabitation is one of the rights, the Islamic legal rights Allah subhanahu wa ta'ala had given upon both the wife and the husband, and it's the rights for both of them, and rights upon both of them that is taken from both of them based on what Allah subhanahu wa ta'ala had legislated him and his Messenger sallallahu alaihi wasallam. And so it is requested from the person who refrained from giving that right. And the person who is not giving the right has the right to request it, whether asking for it or going to the judge to do that thing. And this is the case for the female who is practicing some sort of insubordination, that leaves his house and refuses to stay in it, that it's the right of the husband to file for a lawsuit that would cause her or ask her to come back to live with him, and this is his legal rights. If she still refuses, then her right for financial support is removed from the obligation of the husband. And this is in return because of the hardship and the harm that has been inflicted upon her husband because of her actions. And we have to, unless it is established that she had left her house or home due to a harm that has befallen her. And it's important to note that cohabitation is not permissible between two individuals that don't have a relationship of mahramiyya, unless they are bound together by a marriage contract. Unfortunately, nowadays, this aspect of cohabitation between non-married couples is something that's being spread among the Muslim, whether it's in the media, in the Islamic countries, and this is something that is a violation to the nature and a corruption to the innate predisposition and the nature of the human beings, or Islam as Allah subhanahu wa ta'ala had created them, and this is a outright call to committing zina, fornication, and this is something that does not combine with an individual who has faith and a believer, as Allah subhanahu, as the Prophet ﷺ had mentioned, that the person does not commit zina while he's in a state of iman. And so trying to package the zina as something that is experimenting with one another or temporarily competition to figure out if they're suitable or not is something that is impermissible, and it's a form of cheating and fabrication. However, we should say that sometimes people are forced into a situation where things that can prevent cohabitation, that Allah subhanahu wa ta'ala had legislated certain concessions, and the fuqaha had discussed about certain things that would remove hardship from the person befalls it. A situation for that is, for example, a husband or a wife that has been imprisoned or they have been lost. So certain rulings are associated with that. For example, that the wife could request divorce due to the absence of her husband, whose residency is known, and refuse to come back or bring her to her so that we live together. However, she was not separated from him. She's not ruled as to be divorced from him prior to first having to try to contact him and ask him to come and deal with it. And there's a time span of a certain amount of time that is considered or discussed in the books of fiqh. And if she's harmed by the continuation of the absence of her husband, then she presents her case to the ruler and the judge. The spouse of the person who is imprisoned. Being in prison prevents a person from cohabitation and prevents the rights of the spouses from taking their full rights that are associated with marriage. And if that happens, that it's permissible for them to for the female to request a divorce. However, this can only happen if the imprisonment has went over a specific amount of time. Now, there might be certain situations that one of the spouses might let go of part of their rights in order to fulfill a greater benefit. Certain situations, circumstances that happen that prevent, that can prevent cohabitation, legal cohabitation between them. So either both couples would agree to, to continue as they are and accept it and be okay with it based on the extreme circumstances. However, if there is some sort of harm, then the wife has the right to raise her situation to the ruler or the judge. And some people have the patience. For example, some of the female wives, due to wrong imprisonment of their husbands, they waited for a husband up to 20 years, and Allah subhanahu wa ta'ala rewarded them after they came out. And may Allah reward them for their patience. The last thing the show is going to mention is a quick statement regarding the children that are born out of wedlock. One of the most important objectives is protection of or preservation of lineage. And one of the ways that Allah subhanahu wa ta'ala legislated prevention of lineage is the prohibition of zina and the specific rules associated with the idda, which is the legal waiting period, and the prohibition of claiming lineage of something else or adopting. And the hadith of the Prophet ﷺ, that the child is to the bed of the marriage, and the stoning is for the female that committed zina. And so both the fact that there is a marriage and bed is associated with adultery. So the consensus is that the or not consensus, but the majority of the opinions is that the lineage of the child out of wedlock is not attributed to the male who has committed fornication. The lineage is not affirmed and is not considered that the person's child. And so this is something that's considered neglected. And their evidence for that is the statement of the Prophet ﷺ that for the child is the bed, so essentially bed of marriage, and for the female that commits adultery there is stoning. However, some of the scholars said if there is a person who had committed the fornication, the male, and he claimed that this is his child, and there's no person contending or challenge that person, then we can attribute that child to that father in order to preserve lineage. And the Assembly of Jurists said that we could take that opinion outside the Muslim countries in order to try to avoid the dangers that the child would face if he is born into society not having any sort of knowledge of his lineage. And so based on that, if the child born out of wedlock is attributed or is given to the lineage of the person who claims him due to a form of fornication, then it should be accepted. Wallahu a'lam.
جزا الله شيخنا الشيخ الدكتور صلاح الصاوي خير الجزاء. وكان هذا ختام هذه المحاضرات في هذا المؤتمر المبارك. نسأل الله سبحانه وتعالى أن ينفعنا بما قال مشايخنا وأن يرزقنا شكر نعمته وأن يجعلنا من الذين يستمعون القول فيتبعون أحسنه. Alhamdulillah, this was the conclusion of the sessions of this blessed conference. May Allah subhanahu wa ta'ala accept our mashayikh, and may Allah subhanahu wa ta'ala allow us to continue to benefit from the ilm, Ya Rabb al-Alameen. So inshallah we'll open the floor for around 10-15 minutes of questions before we go for the break and start the open discussion, inshallah. So as usual, one from the sisters, one question from the brothers, and we remind also brothers to address the questions on these sessions that the Sheikh and the Shaykh have covered, inshallah. Bismillah.
The question says that a female came to him to ask to be married to a male that who's not Muslim. And he said to her it's not permissible until he accepts Islam. And so she came a second and a third time, and she came with the fourth time with this person. He wanted to enter Islam, and so he repeated the Shahada after him. However, the Sheikh says that I had doubted in his Islam, that he only accepted Islam so that he would get married. And so when the Sheikh asked him to attend the masjid, to attend Islam 101, he did not come. When he Sheikh said offered that he would teach him how to pray, the person that accepted Islam refuses. In this situation, is it mandatory for me to confirm his Islam before I conduct the marriage, or I should only depend on the fact that he had said the Shahada, and I don't investigate into this matter and leave it to Allah subhanahu wa ta'ala. So Sheikh Salah, he said, based on whether it is the correctness or invalidity of the contract, whomever has entered Islam by admitting his oneness of Allah subhanahu wa ta'ala and the Prophet as the messenger, and he exonerated himself from any sort of false belief, then he was considered a Muslim, and then it is allowed to conduct the contract. Now this is from the original of the ruling. Now, however, when we talk about compatibility and what is the situation, then probably in this case, then it's better to kind of wait and be patient so that we to clarify the truthfulness of this individual and his stability in Islam until both the things that will be settled, and it will be considered beneficial for the female to get married to this person. And so if the Imam believes that if he does not conduct the marriage, that they're going to live there and still cohabitate together and live an unlawful relationship, then maybe perhaps in this situation the Imam will decide that then it is better to conduct the marriage right away. However, the Imam believes and sees that not getting the marriage right away, and that they would wait and not get engaged in some sort of a haram relationship or impermissible relationship, then maybe it might be better in this situation then to wait a little bit and see, make sure that the person's Islam is good before he conducts the marriage for the female. And so this is history. This is where, it goes back to the Imam, where he can decide what is best suited for that situation. Ask Allah Subhanahu wa Taala to guide him.
So, questions from the sisters?
So the question is, here's the situation.
Did you turn it on?
Yeah, you can go ahead. Just for that, take your time.
So a Muslim brother marries a Muslim sister who is a revert.
مسلم تزوج مسلمة ثم طلقها وارتدت
However, he did have 2 children with her.
ولكنه أنجب منها طفلين.
Now she becomes a muqadda, she goes, she has a child out of wedlock.
بعد أن ارتدت أنجبت من علاقة زنا. فهل هذا الطفل يعتبر أخ للأطفال؟ وهل هذا الطفل يعتبر محرم لزوجها السابق أم لا؟ فما هي العلاقة بين هذا الولد الزنا وإخوته من الأم وعلاقته مع طليقها؟ بناء على ما فهمته،
No, he did. So you're married to someone who, according to the Sharia, they're both Muslim. However, she was a revert as a matter. Now, yeah, he divorces her, she becomes muqadda. This is his ex-wife, becomes muqadda. Now that she has a child out of wedlock, what is the relationship of that child? Is she mahram to the brother that was married to her? And what is the relationship to her after?
مشايخ يتأكدون من السؤال. فالسؤال هو أو الحالة هي أنه كان هناك مسلم تزوج من مسلمة ثم طلقها وكان أنجب منها طفلين، فبعد أن طلقت المرأة ارتدت ثم زنت وأنجبت من هذا الزنا، فهذا الولد فهذه بنت الزنا هل تعتبر محرم لطليقها وهل لها محرمية للإخوة؟ Sheikh Salah was saying that being a mahram has nothing to do with faith. And so, for example, if a Muslim female has a non-Muslim brother and she has a child, then that niece is considered a mahram to the non-Muslim uncle. There are of course some exceptions. So for example, one of the mahram is a person who is sinful and he would do things that are haram, or he would tell others what, for example, the female would look like. Then in this case, they should not stay in solitude or seclusion with them on their own. And so they're qisas al-muhram, but you got to take the proper appropriate measures to kind of protect the individual, to protect themselves.
And she considered the sister of the boys. She's still her half sister. Yes.
فالشيخ ذكر أن هذه البنت التي ولدت من سفاح تكون إخوة لأخواتها من أمهم. So some of the females come to the masjid, they come if they don't have a wali, and so she appoints the imam as a guardian to conduct the marriage. So what are the boundaries of that guardianship to the imam in this case? And what are the rights that he's supposed to fulfill? بالنسبة for the Muslim convert that does not have parents that are Muslims, then there is no guardians, because there's no guardianship of a non-Muslim over a Muslim. And so in this case, this female that had converted to Islam, her guardian would be the imam, and perhaps this guardianship there's a bit of a misunderstanding in what this whole aspect is, that they would assume that the imam would become their guardian in everything, who's responsible for taking care of her and financial needs, and not just in marriage. And this is a misunderstanding. He's only a guardian in her nikah, in her marriage, and that is it. That's the limit of his responsibilities. The question is asking: is there a limit to the time of the guardianship of the imam? And the sheikh has answered that the time frame is until the marriage is conducted. Beyond that there is no sort of guardianship over. Of course, we have to bear in mind that the imam obviously is not a mahram for her or anything like that. So all Islamic boundaries have to be established. He's just only a guardian in the aspect of marriage. ولد ولد من سفاح ولزنا. فإذا إذا ولدت بنت من سفاح فإن نشأت وكبرت وكانت ووصلت مرحلة الزواج، من يكون وليها؟ فمن يكون ولي المرأة التي ولدت من سفاح؟ فأجاب الشيخ فإن في هذه الحالة الإمام قد يكون وليها. The Sheikh said a small footnote: if the female who's born out of zina, if her father who committed that zina claims her, then it is fine; it becomes her wali. However, if that doesn't happen, then the wali or the ruler becomes the guardian of the one who does not have a guardian, and this is limited to just the nikah or marriage. And there's no harm if that can be extended, if she has good assumption of him and she thinks of him as a father, that he fulfill certain things in terms of advising her. A question was asked, the brother of the mother, who's a khal, is he considered a wali? The Sheikh said no. However, it is wilaya is in the asab, which is have to do from the male side, would be either the children or going upwards in terms of father or grandfathers.
Take more questions. It's now time to break to the 10 minutes for break.
It's 10 minutes break, and then we have an hour and 15 minutes Q&A.
So for now, any more questions other than the last question?
This is the last question.
Oh, Sister, please go ahead. So it's the last question, and inshallah, any more questions? Also, Sheikh will be posting another question here. So with your permission, inshallah, we'll have one more. Sister, please go ahead.
What is the ruling of permanent forms of contraceptive after having children with the approval of both couples, the husband and wife? The Sheikh is saying that it's permissible, provided that the form of contraception is something that is still temporary. So it's not a form of contraceptive that would eliminate the ability of the husband or female to possibly have future offsprings, such as vasectomy, for example, or removal of the eggs of the female or the uterus, unless, of course, there is a medical reason. And so the main thing aspect is that it is temporary means and it's not permanent means that would result into the male or the female to become barren and not able to reproduce in the future. And only in situations where the doctor would deem that there is harm upon the female if she does not conduct some sort of an operation that will result in permanent form of contraception. In this case, this is something else. Or even if a pregnancy would result into the loss of life or affect the health of the female, then in this case, a permanent means of contraception would be permissible. This is based on medical judgment.
So the last question.
I apologize for taking this time to break. The question is
السؤال
attributed to the fed of where the baby is born. Does that mean the DNA paternal test, is that haram? Is that discouraged? The DNA
زوج المرأة التي زنت التي حملت وقلنا أن الولد للفراش فينسب الولد إلى الفراش، ففي هذه قلنا بهذا الحال فهل الكشف بالحامض النووي عن الأبوة فهل هذا حرام؟ فهل يحرم ذلك أم لا؟ Based on that, there was several Islamic things associated with his knowing the real father and the aspect of lineage and the aspects of mahram. And Sheikh Mustafa Zarqa, from a long time, he said that DNA testing أو الكشف بالحامض النووي يعتبر دليل طبي شرعا ويؤخذ به. The Sheikh Salah is adding just an additional footnote. We mentioned that lineage is a familial connection, And it's not just a biological relationship. It is an affiliation, a legal affiliation that goes from ancestry from one to the other. And from the ways of confirming it is the bed. And so we say that the child is to the bed, and for the female that committed she gets the penal code. And so if a female commits zina, then whatever offspring happens is for her husband, and she should not strike the door of opening the door to test with the DNA or to do that paternal testing, because this will open a great door of harm, and as legislation have been mentioned. However, when there is a dispute regarding that matter, for example, like Sa'd ibn Waqqas, for example, he said regarding his brother that this is my brother, that my father said that he is my brother because his father had committed zina with another female, and there's clear similarity in terms of features between the two companions, and the other one is disputing that this child was born on my father's bed. And so the Prophet ﷺ said, the child is to the bed, and to the female there is a penal code, and he asked Sauda, his wife, to conceal herself. And so when it comes to lineage, it go to the default, which is that it belongs to the husband who the bed was born in, and we take precautions in terms of the mahramay. And so paternal testing, such as DNA, should only be utilized and directed through the legal means. And so even in Saudi Arabia, paternal testing is only done when the husband goes through the process of mulana, cursing, where the wife, where he is accusing the wife, for example, of committing some sort of zina, and she's denying it. Then the judicial system would resort to paternal testing as a means that would affirm the husband's suspicions or not. And so in Sharia, there are certain limitations in Sharia that would limit the use of paternal testing. There are its means and uses, like to establish things, for example, a mix-up between babies in the hospitals, and so there is a reason to utilize or use the genetic testing to confirm the paternal affiliation. This is something that is legislated, and there is reason for it. However, we should not open the door regarding matters of aspects of zina, adultery has been committed, and a child has been born. And so the question is asked: what if the female is not married? Sheikh said that in the judicial system there is legal Islamic legal aspects that limit things. So the Sheikh is saying that there are certain situations where it warrants that we do some DNA paternal testing, for example. And so the Sheikh is asking again, what if there is no firash, which means that regarding paternal testing when the woman was not married. So the Sheikh is saying if the adulterers two men had illicit sexual relationship with a woman that is not married, then let them solve their problems away from us. And we are ending this part of the session, inshallah.